Good morning.
Donald Patton, Sergeant First Class, U.S. Army, retired. Your Honor, I'm appearing today as a pro se litigant. I have a non-attorney assistant, Rachel, who's been helping me organize and manage
Your
my
on-screen
documents.
assistant is, unless they are an attorney at law, they are not going to be allowed to participate in this hearing. The practice of law is limited to those people who have been licensed by the state of Tennessee to practice in the courts of the state of Tennessee. And an on-screen assistant is not someone who, unless they are shown to have an actual license to practice law, they will not be allowed to participate in this case.
Yes, Your Honor. My ask was to allow her to assist me with the documentations of getting it sorted so that we had it present and quickly for me, not to, as an assistant with regard to any kind of...
As stated before, if she is online, she's been admitted into this hearing room, but she is not going to be allowed to participate in the case.
Understood.
You have filed a petition for emergency ex parte temporary restraining order and a motion for an expedited hearing. And I think there was a hearing in front of Judge Larry Wallace, is that correct?
Yes, Your Honor.
And Judge Wallace denied your request for an emergency ex parte temporary restraining order and then set the matter for this court to hear. And that order was entered on June the 4th. And basically that order recites the following. The court reviewed all of the recent pleadings filed by the plaintiff on June 2nd. In addition, the court reviewed the detailed final decree of divorce, which was entered on August 21st of 2025. When reviewing the totality of the pleadings in this case, the court believes that there is insufficient proof at this time to grant an ex parte temporary restraining order. Moreover, the court noted that in the final decree of divorce that the plaintiff lacked credibility on many issues. Nevertheless, the court does set this matter for hearing on Monday, June 15th, 2026 at 9 a.m. in the Dixon County
Right from the beginning, the judge makes it clear that this is not a brand new case. Another judge already reviewed the emergency request and declined to grant immediate relief. Now the court is taking a closer look at whether there is any legal basis for moving forward.
In the Dixon County Justice Center in Dixon County Chancery Courtroom 5. So basically, Judge Wallace has deferred it to me to hear. So we are here today on your request for an ex parte, and I noticed that you this morning have filed a motion for Rule 60 relief from the judgment in this case. I would simply observe that under the rules of civil procedure, to hear a motion, you must give 5 days advance notice to the opposing party. So Ms. Duke, are you opposed to hearing on the Rule 60 relief without proper notice? Rule has been requested, so anyone who is going to be a witness in this case must go outside of the courtroom and remain outside of the courtroom until you are called to testify.
May I grab my documentation,
You may.
Your Honor?
We will not be hearing your Rule 60 motion because the not proper notice has not been given under the rules. So you're limited to your ex parte or your motion for a restraining order.
Understood, Your Honor. I have a opening statement prepared. All right, Your Honor, this morning I filed a Rule 60-102 derived from motion for relief from final judgment, setting forth 10 specific grounds for relief derived specific part this court's own audio record. A motion for evidentiary hearing, requesting a full hearing on those grounds no later than August 3rd, 2026, within...
What are you referring to when you make this statement?
I'm just trying to let the court know that I filed this morning, Your Honor.
Well, what you filed this morning is not before the court because you've not given proper notice. We are not considering a Rule 60 motion, so I sustain the
Understood.
objection.
This is a critical moment. The judge is narrowing the case to a single issue and refusing to discuss unrelated motions. Courts often do this to keep hearings focused and prevent parties from expanding the dispute beyond the matter scheduled for review.
Okay.
You have asked for a restraining order, and that's the only issue that's before me today.
Okay. Understood, Your Honor. Your Honor, circumstances have developed since the entry of the final decree that have rendered the current property arrangement financially untenable for both parties and impossible to perform as written. The homeowner's insurance on the marital residence at 2358 Petty Road, Charlotte, Tennessee has been canceled effective June 3rd. Neither party is legally able to reinstate that insurance policy at this time. I do not occupy the property, which is required by the policy, or insurance policies in general, and the respondent is not a mortgage holder of the home itself. PennyMac has confirmed that they will place.
You cannot repeat what a bank or an insurance company or anyone who's not a witness from the witness stand has said. That would be hearsay. So I sustain the objection. Ms. Duke, turn on that microphone there, please.
Sorry, I didn't realize it wasn't on.
You need to confer with your client. You can turn it off, but if you don't mind leaving it on, that way you don't have to turn it on and off all the time.
Yes, sir, thanks.
Your Honor, so there is a forced policy that will be put in place by PennyMac.
Well, let me ask you this question. You've read the final decree of divorce,
Yes, Your Honor.
and you're aware that under the final decree of divorce, that she was granted ownership of that house, correct?
Yes, Your Honor.
And that your claims against the equity in that house were offset by the $50,000 or so that I found that had been invested or that had been wrongfully taken out of marital funds in the final decree. That was the reason why she got the entirety of the equity in the home, and that you were to be divested of that interest. And so she's the owner of that property under that final decree, which was entered August 21st of 2025.
Now, the judge asks the key question. A restraining order is an extraordinary remedy, so the court needs a very specific action that should be stopped or required. General concerns are usually not enough.
So what exactly are you saying she should be restrained from doing?
Your Honor, the original TRO the request was to put me on the property as an occupant so that I could reinstate the insurance policy, because the insurance policy was dropped due to not being an occupant of the home. So that was the sole purpose of that emergency TRO, was to try to reinstate the insurance policy so that my family was covered, and all of their belongings and everything was covered within their insurance. So,
Respectfully, we've had to file the final decree of divorce. I've sent him an email about that, had it at the office. He's come by the office several times and never signed the quit claim deed. My client is able to get the home. She's had to go to the Register of Deeds office and register the final decree, as opposed to the quit claim deed required to sign under court order.
Your Honor, signing over my rights to a property that I am solely liable for puts me completely upside down, and it's completely inequitable.
Why wouldn't you sign a quitclaim deed?
Why wouldn't I sign it?
Yes, sir.
Because that removes all rights that I have of any access to that property when I still maintain the mortgage solely in my name. It's a VA mortgage.
She can't, you understand, she can't get a change in the mortgage unless she owns the property outright. The order the final decree rather, provides that the marital residence located at 2358 Petty Road, Charlotte, Tennessee, 307036 is awarded to the wife. Any and all marital interest the husband has to the real property is hereby divested from him and vested in the wife. And Ms. Duke, do I understand you have recorded that final decree?
We've recorded the final decree.
The discussion is shifting away from the emergency request and toward ownership of the property itself. The judge appears focused on resolving practical issues surrounding the home and mortgage
The final
obligations.
decree, but we also brought a quit claim deed here today for him to sign if the court was inclined to instruct him to sign it.
So the final decree in the order that this court put down over a year ago is awarding her that property and divesting you of any interest. So you no longer own an interest in that house.
Yes, I'm aware, Your Honor.
To order to get the mortgage changed out of your name and to put it into her name solely, she has to have whatever the documentation is that's necessary. A quitclaim deed is a deed that says whatever interest I have in the property, I'm conveying to the other person. And you're not making any warranties, you're not doing anything other than saying, I don't have any other interest in the property. So with that being the case, it would make sense that it is in your best interest to sign the quitclaim deed to the property so that she can then get the mortgage into her name individually. Is that what she intends to try to do, Mr. Duke?
Yes, Your Honor. That's what she's been working towards for the last year. And I would submit to Your Honor, this all revolves around a $31,000 insurance check she received for damage to the property after the property was awarded to her. She turned it into insurance, did everything she was supposed to. And he's making some claim to an insurance proceeds check for damages to the real property that she owns. So that's where this kind of came to a head, and we just need him to sign this and to sign the insurance check.
Even after hearing arguments from both sides, the judge gives the petitioner another chance to clearly explain what relief is being requested. This is often done to ensure the record is complete before a ruling is made.
All right. I've interrupted you, but I want to give you an opportunity to, again, explain to me what it is you're seeking to do in this temporary restraining order that you sought, which is all I'm hearing today.
Yes, Your Honor. Once again, so the only purpose for the temporary restraining order was to get me put in a situation where I had occupancy to reinstate the insurance policy, because the insurance policy would drop due to occupancy. So I was trying to reinstate that. That window has passed and closed. The insurance is now closed and gone. That policy's been shut down. The property currently is valued roughly around $300,000 as per the CMA that I just received. And it's now sitting completely uninsured at the moment, Your Honor, it's not good for both the mortgage, it's not good for my VA entitlement, it's not good for our children, to have this house completely unsecured and just floating in the wind.
As we understand it, and I think that if records were subpoenaed, I think the records would reflect that he actually called and canceled the homeowner's insurance policy, which obviously is in bad faith, and it's actually, similar to the things that he did during the divorce. It's all to get at Ms. Patton because
This may be the most important turning point in the hearing. The judge is offering an opportunity to present sworn testimony and evidence. Without evidence, it becomes much harder to convince the court that emergency relief is necessary.
All right, well, I've allowed you to make an opening statement, but it was unsworn statement. So if you want to put on your proof, I'm going to let you be placed under oath and take the stand, and we'll let you testify about what it is you're asking me to do. Do you wish to put on proof on this issue?
No, I don't believe so, Your Honor. I mean, I think if that's kind of where we're at, like I said, the TRO it's kind of come and gone at this point.
All right, since you have declined to put on any proof, that is this
The court has now moved into solution mode. Instead of granting the requested restraining order, the judge is attempting to resolve the underlying property and insurance issues by clarifying ownership responsibilities.
Proof that is this court's order that you signed that quitclaim deed, and that thereafter, Mrs. Patton will be required to obtain insurance on the property in her name only. She will be required to seek and obtain replacement mortgage coverage for the home to release Mr. Patton from all liability on that. As any idea of time was how that, if he signs it today, any indication as to how long that will take?
There isn't, Judge, because we've not been able to get to that point due to the quitclaim deed. If we need to set it for a review some 60 days out, I think we could do that.
All right, set it, give me a date, 60 days out. I want to get you released from the liability on the mortgage and give
Notice
you what
that
you
the
need.
judge is focusing on practical outcomes rather than past disagreements. The goal is to reduce future conflict and protect both parties from additional financial risk.
Mortgage and give you what you need. And
Yes,
that
sir.
way, I understand you, if there's no insurance on it, then there's a risk to, both of you for that. So we're trying to fix your problems as quickly and expeditiously as possible. So with me ordering you to sign the quitclaim deed, it still preserves your right to argue that Rule 60 motion if you want to. But I'm going to try to fix these things as quickly as possible to let her obtain the insurance immediately and to then to take the steps to try to release you from the mortgage.
Okay.
And we'll do those, we'll set a review 60 days down the road to make sure she's done those things.
Sounds good, Your Honor.
Right. That'll be August 26th.
Yes, Your Honor, I'm available that day.
All right. That'll be in front of a different judge, but the order will reflect what I've done, and that should take care of it.
And that 60 days is not, that's just a review to make sure.
It's a review to see if what progress she's made in complying with the court's order that she obtain insurance in the property in her name only, and that she take steps to try to get the financing to release Mr. Patton.
And
Okay.
may I request that he be required to sign that check if I put it at the front desk at my office?
Once I awarded that property to her, the check is hers from the insurance company. So yes, I'll order that Mr. Patton.
With that
needs to
final instruction, the court has addressed the major disputes raised during today's hearing. The case isn't completely over, but the judge has established a clear path forward and scheduled a future review to monitor compliance.
Mr. Patton needs to sign that check over to her as well. All right, then Ms. Duke's going to draw an order and submit it to you for, so that you'll see what the order says and make sure it is correct. And then I will sign it after that. All right, thank you.
The only other issue was fees being awarded in this matter.
No, that will be reserved.
Thank you, Judge. I'll make sure I put that in the order.
All right. Then that concludes our business for today. You two lawyers, huh? Oh, no. Wait a minute. I thought that was it.
Right here. Yeah, 15.
I see it, okay. The motion for a mandatory injunction in Williams versus GCD Enterprise.
Yes, Your Honor, it should be pretty easy. We filed that motion, I thought we sent a copy to Mr. Mills, I don't believe it was sent.
I didn't see any service in the file this morning. I think there's no return of service of process. And then, so I can't do anything until there is a service on the defendant, but
I spoke with Mr. Mills on Friday, and what I told him I was gonna come do is ask the court if there are any other days in June that the court could accommodate.
any other day in June.
Accommodate a hearing on this case, yes, sir.
Well, this is not even I'm supposed to be in Waverly, Tennessee today. And the only reason I'm holding these days court is because trial got continued. I don't have any other chancery days in June here in Dixon County, but do you have another day in June? I mean, tomorrow is the only other chancery day until after July. July 1st? What do you want to do?
Yeah, I guess we'll check to see if anybody else, of course, is, that's. the reason
Check with Judge Turnbow. He's in his office today. He
That
might
was
be
the
able to
reason
give
for the
you.
injunction was, we were needing relief as quickly as possible. So.
I understand from what your pleadings state that there's an urgency to it, and I'm sorry I don't have any open days to give you after tomorrow. I will say that if you will check with Judge Turnbow, he might be able to, if he's had some openings, he might be able to work you in. So
Yes, Your Honor.
don't mean to speak for him.
Thank you, Your Honor.
All right. Mr. Spratt, why are you here?